Hello everyone, how are you all? This is your friend CA Rohit Grover, and here I am, your faculty for CA Final Paper number 3, Advanced Auditing and Professional Ethics. So, friends, I just wanted to clarify one thing. Like, there is a recent amendment which has come in a very important chapter called Audit Committee and Corporate Governance. So, I think we all are aware about that particular amendment, but that amendment, when you look at the revisionary test paper, when you look at the RTP of the May 2020, the basically that amendment is not for November 2020. It did not get introduced for the November 2020. It was already introduced for the May 2020, but as we all know that unfortunately the May examinations have not taken place. So just because the May examinations have not taken place, so that's why this amendment becomes highly important when it comes to the November 2020 examinations, right? So sir, looking at the picture in front of you only, you all might have understood this particular amendment is relating to what if the statutory auditor of the listed entity resigns. What this amendment is all about: what if the statutory auditor of the listed company resigns, or its material subsidiary statutory auditor also resigns. So here we are going to cover not only for the listed entity, we are going to cover the provisions relating to statutory auditor of the listed entity as well as the statutory auditor of its material subsidiary also. Now, say for example, something wrong has happened. Am I correct or not? Now, as you all know that section number 132 is becoming very prevalent nowadays. I don't know how many of you are aware about this section or not. The name of the section is known as NFRA, right or not? National Financial Reporting Authority. We might have seen that in the month of July, so many punishments have been incurred, or so many punishments have been imposed on the auditors of Deloitte or on the auditors of PwC. And why it is happening? Because unethical practices were happening in the listed entities. So what this provision is basically all about, what this amendment is basically all about, in this amendment we are going to cover very important aspects. Now, what are the three major things we are going to cover in this amendment? Particularly, suppose if the statutory auditor of a listed company, first of all, sir, to which chapter it belongs? It is an amendment belonging to the chapter called Audit Committee and Corporate Governance. So what is the amendment? This amendment says that if the statutory auditor of the listed company resigns, are you getting the point? If the statutory auditor of the listed company resigns, and if the statutory auditor of its material subsidiary also resigns. Point number one, statutory auditor of the listed entity resigns, and statutory auditor of its material subsidiary also resigned. So either of the two cases, either the statutory auditor of the listed entity resigned or the statutory auditor of the material subsidiary resigned, then what is the responsibility of that listed company? What is the responsibility of the audit committee of that listed company? And what is the responsibility of the auditor? Are you understanding the point? So what is the auditor of that listed company whose auditor has resigned? What is the responsibility of the audit committee of that listed entity whose auditor has resigned? And most importantly, what is the responsibility of that auditor also who has resigned? Are you understanding the point or not? So this is basically, we are going to understand about the responsibility of the listed entity, responsibility of the audit committee, and the responsibility of the auditor himself if he resigns from what? Sir, if he resigns from that particular listed entity or from its material subsidiary. Now, before going into the resignation, let us go back to section number 140, subsection 2 and subsection 3, which were available in the Companies Act. Sir, why suddenly Companies Act has been introduced here? We are going to talk about LODR. For those who don't know what do you mean by LODR, when you will read this chapter called Audit Committee and Corporate Governance, LODR stands for Listing Obligations and Disclosure Requirements. These listing obligation and disclosure requirements are not applicable to every company. They are only applicable to whom? They are only applicable to whom? They are applicable only to the listed entities. So in the audit committee and corporate governance chapter, everything is relating to listed entities. Then sir, why you are talking about section number 140 subsection 2 and subsection 3 of the Companies Act? Because those sections also talks about the resignation of an auditor. So let's just quickly just have an idea कि what section number 140 subsection 2 and what section number 140 subsection 3 were talking about. Section number 140 subsection 2, if we remember, it was talking about the resignation of an auditor. If the auditor resigns, if the auditor resigns willingly from a company, then it is his responsibility that within the 30 days of his resignation, within the 30 days of his resignation, he should ensure that the reasons of his resignation must be intimated to the authorities. So within the 30 days of the resignation, the reasons of his resignation must be intimated to the authority. Sir, what do you mean by authority here? If you were an auditor of a non-government company and you resigned, then the authority is company and ROC. So within 30 days, you have to intimate the reasons of your resignation to the company and to the ROC. In form number ADT 3. What is the form number? ADT 3. And in case you were an auditor of a government company and you are resigning, within 30 days, you should have intimated it to whom? The C&AG, Comptroller and Auditor General of India, again within 30 days in form number ADT 3. What? Reasons of resignation. This is what was written in the Companies Act 2013. Now, what they are saying that Companies Act 2013 provision is also applicable to listed entities, because listed entity means company only, na? So Companies Act 2013 provisions तो already applicable. It means you have to intimate it to the say C&AG and you have to intimate to the ROC, you have to intimate it to the company. But along with that, if you are a listed entity, if you are which entity? Listed company, you also have to intimate about the resignation of your auditor. Sir, which auditor? Statutory auditor. To whom? To the stock exchange also. You all have to intimate about the resignation of your auditor of a listed company to whom? Stock exchange also. So the new amendment is no more only to the C&AG or a company or an ROC. Who is the fourth person also included? Stock exchanges also. So if you're a listed company, you have to intimate the reasons of resignation of your statutory auditor and that your statutory auditor has resigned within 24 hours. Sir, 24 hours means what? Is it the 24 hours from the resignation? No. Within 24 hours from receiving the reasons of resignation from the auditor. Are you getting the point? So you have to intimate to the stock exchange as a listed company within 24 hours. Sir, 24 hours will start from where? From the moment you receive the reasons of resignation from the auditor. Once the company received the reasons of resignation from the auditor, within 24 hours, such reasons and such intimation must be given to the stock exchange within 24 hours. Clear, everyone? That is the major idea, major amendment, what we are going to understand. Now the question is, sir, why stock exchange has been involved? What is the reason? It's a very simple thing, sir. We are talking about a listed company today. Now, when the listed company's statutory auditor resigns, think logically from the macro point of view. Listed company means what? Lakhs and lakhs of people have trusted this company. Lakhs and lakhs of people have financial interest in this company. Lakhs and lakhs of investors have invested their hard-earned money in this company. Don't you think that they will be in the worrying situation? Don't you think that the investors will be worried? Don't you think that lenders will be worried? Don't you think that stakeholders will be worried? Why the statutory auditor of this particular listed company has resigned? Let me give you an example. Say for example, tomorrow news comes कि statutory auditor of Reliance India Limited has resigned. Don't you think that all the shareholders of the Reliance India Limited will be worried कि what thing has happened in the company that the statutory auditor has resigned? Investors' point of view, investors' concern is highly important. Therefore, SEBI under its LODR regulations made an amendment. What is amendment? If your statutory auditor is resigning, sir, as a listed company or as a material subsidiary, then you have to intimate the reasons of the resignation, intimate the resignation of your statutory auditor to the stock exchange within 24 hours. The moment you receive, the resignations, reasons of resignation from your auditor. So within 24 hours, when you have received it within 24 hours, stock exchange also must know that your statutory auditor has resigned. But that is not the only amendment. That is not the only amendment. There are so many things which we have to understand inside that. What is the responsibility of the auditor in that case? What is the responsibility of the audit committee in that case? What is the responsibility of the listed company in that case? All those things we have to understand one by one. So each and every word, directly it's a copy paste of RTP wording. What is written in your RTP, directly I have copy pasted here, and each and every word relating to the RTP I'm going to discuss. So I'm posting this video on the YouTube. Why? The only reason is so that students can get benefited about this amendment, because so many of us or so many of the student community is still unaware about some small issues which we have to cover in this particular amendment. And as you know that Rohit Grover sir is not at all going to leave even a single word unread or even a single page unturned. Each and every word, especially I already tell to my existing students ki sir, when you are doing this audit committee and corporate governance chapter, the only thing is you have to make sure that each and every word must be read. I hope all of you understood the introduction of this amendment. So what is the introduction of this amendment? Resignation of statutory auditor from the listed entity and their material subsidiaries. So what that particular thing is saying. So first we are talking about what? Auditor's responsibility under the Companies Act. As I already discussed with you, so we need not discuss that in detail. As per section number 140 subsection 2, specifies the procedure to be followed by the auditor when he or she resigns from the company. Procedure says that you file the statement in the prescribed form. Sir, everyone please tell me what is that prescribed form? Sir, ADT 3. We have to file with the company and the ROC within how many days? Sir, within 30 days. Within how many days we have to file it? Sir, within 30 days from the date of resignation we have to file. So file a statement in the prescribed form with the company and the ROC within how many days? Sir, within 30 days from the date of resignation. And for the government companies, I already told you. For the central government or state government companies, the same reasons of resignation are required to be filed by the auditor to the C&AG in the form ADT 3 within 30 days from his resignation. So that is what all is being told in this first paragraph. So you can say that basically this paragraph is completely dedicated to which provision? Companies Act provision, which we have already covered earlier, and I already told you in the beginning of this particular topic also. And in that form, what will be written? Statement should indicate the reasons and the other facts as may be relevant with respect to such a resignation. So this we need not do, because this is the responsibility of the auditor under the which act? Under the Companies Act. But are we doing it under the Companies Act? No, we are understanding the responsibility of the auditor under the LODR regulation. Let us understand responsibility of the entity under SEBI LODR regulations 2015. So it is a very important amendment, sir. So what this amendment is basically saying? This amendment is saying that, sir, from the 1st April 2019 onwards, what is the date? From the 1st April 2019 onwards, in any listed entity, if the statutory auditor of that listed entity or its material subsidiaries its material subsidiaries series leaves or resigns the listed entity and its material subsidiary, then it is the responsibility of that listed entity to inform to the stock exchange within 24 hours from the reasons received from such auditor. Now this is what is written in this whole paragraph, so that we already know. From 1st April 2019, the Security Exchange Board of India, via its LODR, Listing Obligation and Disclosure Requirements 2015, cast a responsibility on the listed entity. Didn't I tell you that we have to understand the responsibility of listed entity? Now, what is the responsibility of listed entity in relation to an auditor's resignation? So, what is that responsibility? The listed entities are required to disclose the detailed reasons to whom? To the stock exchange. To the which exchange? To the stock exchange, where there is a resignation by an auditor, as soon as possible, but not later than 24 hours of receipt of such reasons from that auditor. The moment you receive the reasons from the auditor why he is resigning, within 24 hours that must be intimated to the stock exchange. That's it. This is what the time period. So sir, let us write what is the time period. The listed entity, now what is the time period? Here the listed entity must inform stock exchange. The listed entity must inform the stock exchange what? That their auditor has resigned with reasons. Sir, when the listed entity will be able to give the reasons to the stock exchange, when the listed entity itself will receive the reasons of resignation. So when to be informed? When to be informed? Within 24 hours from within 24 hours from the moment it received reasons of resignation from their auditor. So remember one thing, guys. Always remember one thing. It will take some time to complete this amendment. Sir, एक ही तो amendment है. Why you think that कि 45 minutes to 1 hour is required? Sir, each and every word is required to be understood. Try to understand my point very clearly. Leaving the video in between is going to be your loss. You are going to lose some important interpretations, some important points which you never ever given importance to. That is what the problem with the student community. So that's the reason people like us have to come up with a responsibility to make sure that ki bhaiya, this particular point is also very important from the examination point of view. Clear everyone? So we understood the page number 1. In the page number 1 we understood what is the responsibility of resignation as per Companies Act 2013 and what is the responsibility of the listed entity if the statutory auditor resigns. Now aspects to be covered to all listed entities. What is the next topic, sir? Aspects to be covered in circular to all the listed entities. Now what the SEBI says, that what is actually written in that circular? SEBI has issued a circular clarifying mandatory condition to be complied with when the statutory auditor of a listed entity or its material subsidiary resigns in relation to limited review audit report, and the circular issued by the SEBI comes into with the special effect. Now listen to this very carefully. Listen to this very carefully. They are saying that this is mandatory circular, and the moment it came from that immediate effect only this circular is applicable. Why? Because it is all about the concern of the outsiders, investors, lenders, stakeholders. Don't you think that we have to keep them informed if their statutory auditor of the listed entity in which they have invested or lended the money and that person has resigned? So there might be some problematic things which might be going on in their mind. So for the removal of the doubt, stock exchange co listed entity will inform it to the stock exchange, and stock exchange will inform it to its investors by publishing it. So when this amendment came, sir, this amendment came on October 18, 2019. When this amendment came, sir, October 18, 2019, this amendment came, and with immediate effect it is applicable. And remember, those companies in which audit committee is not constituted, those companies where in which what audit committee is not constituted, then in that case board of directors will take care of this compliance. Generally, this is the compliance applicable on which committee? Sir, audit committee. As we all know that audit committee is mandatorily required to be constituted in a listed entity. But still SEBI has clarified that in such companies, if the audit committee is not constituted, then who will take care of this responsibility? Board of directors. Generally, the whole responsibility relating to resignation of the statutory auditor is lying on the shoulders of whom? Audit committee. But in case audit committee is not there, the whole responsibility lies on the shoulders of whom? On the board of directors. So what they are saying now, see that in case an entity is not required to form or constitute an audit committee, then the board of directors of the entity are required to ensure compliance with this circular. That is what I told you. So they are saying that generally it is a responsibility of audit committee, but if audit committee is not constituted, then everyone please try to fill in the blanks, then board of directors must comply. That is what written in this particular topic. then in that case board of directors must comply with that. Clear everyone? Now what are the aspects to be covered, what are the conditions to be complied with, what are the procedures to be followed, and what are the obligations of listed entity and its subsidiaries? Now we are going to understand this particular amendment in detail. Now very much in detail we are going to understand. Now listen to this little bit tricky part. Now we are going to first understand auditor's responsibility, what auditor has to do. Then we'll understand audit committee's responsibility, and then we'll understand listed entities' responsibility. Each and every what we are going to discuss in the next half an hour, 45 minutes of discussion, it is highly important. Right now, what the SEBI has said. So what I will do is I will make sure that I will read each and every word, and I will put my interpretation in that, and I'll write it on the left side of that so that all of you can make a note of it in a very important and a beautiful manner. Now, SEBI has also clarified that in case the auditor is rendered disqualified due to the operation of any condition mentioned in section number 141 of this act, then the provision of this circular would not be applicable. Now, what they are saying that, everyone please tell me, Companies Act section number 141 talks about what? 141 subsection 3 talks about what? Disqualification. And 140 subsection 2 or subsection 3 talks about what? Sir, resignation of an auditor. It means the SEBI has very much clarified in this point that if it is a resignation case, then this SEBI circular is what? Optional or mandatory? Then the whole provision what we are going to understand is mandatory. But in case the auditor left due to disqualifications under section 141 subsection 3, in case the auditor left due to disqualifications under section 141 subsection 3, then this circular is not applicable in that case. Are you guys understanding the depth of the provision? So SEBI has clarified that ki bhaiya, if it is resignation, then this circular is applicable. If this is not a case of resignation, if this is a case of disqualification, then this circular is not applicable. So we will read the point to point thing, and I'll make sure that I'm writing the notes in, opposite to that. You just pause the video, make a notes, and make sure that you are doing this particular amendment in the same way in which I want to teach you. Right, sir? Next point. Conditions to be complied while appointing or reappointing an auditor. Now let me just first tell you what is my understanding says, then we'll see our understanding in the particular video or in the particular provision also. So let me take some notes for you, all of you. Now what they're saying that, let's take an example ki 2021 financial year is going on. So which financial year is going on? 2021 financial year going on. So this is the total 2021 financial year, right? So this is 1st April 2020 and this is 31st March 2021, correct? This is the 2021 financial. Now listen to this, we have to divide it into 4 equal quarters. So quarter number 1, quarter number 2, quarter number 3. So are we able to see the first quarter? The first quarter is ending on 30th June 2020. Third quarter is ending on 30th September 2020, and then 31/12/2020, and then that quarter, right or not? So this is Q1. So let us understand, this is Q1, this is Q2, this is Q3, this is Q4. Now try to understand this provision, very important, highly important provision. They are saying that in case the auditor, now listen to this, let's do the half of this quarter, assuming that quarter is having 90 days. Assuming that the quarter is having 90 days. If an auditor, if the statutory auditor of what? Of listed entity or its material subsidiary. Now listen to the point number 1. If the statutory auditor of a listed entity or its material subsidiary is leaving, is resigning within 45 days from the end of quarter. They are saying that if the statutory auditor of the listed company or the material subsidiary is resigning within how many days? 45 days. It means we are talking about these 45 days. We are talking about these 45 days. Within 45 days from the end of the quarter. Now, which quarter they are talking about? So, as per our example, within 45 days from Q1. So are you understanding the point? So within the 45 days from the end of the quarter, sir, when the quarter is ending, the quarter is ending on 30th June 2020. Within 45 days means what? Okay, within 15 July, within 15 August, sorry, within 15 August 2020. 45 days, within 45 days means what, sir? Quarter one is ending when? 30th June 2020. Within 45 days. So add 45 days, maximum within 15 August. So within 15 August, from 1st July to 15 August. So it means from 1st July to 15 August. If the statutory auditor is resigning, then what is the statutory auditor's responsibility? Then what is the statutory auditor's responsibility? He has to ensure that he shall complete audit or limited review or and issue report on previous quarter before resigning. Correct, everyone? What they are saying that if the auditor is leaving within the 45 days from the end of the quarter, then he is responsible to do the audit or complete the audit of that previous quarter and do the limited review of that previous quarter and must issue the auditor's report or limited review report before leaving and before resigning. Are you getting the point? Now the situation is very different here. So what is the situation number 2? If the statutory auditor of listed company or material subsidiary, sir, resigns when? Resigns after 45 days from the end of quarter. Sir, after 45 days from the end of the quarter means what? Okay, now I'm talking about this thing. Now I'm talking about these 45 days. So first 45 days and the second 45 days. It means now I'm talking about these 45 days. So if the auditor is leaving here now, when the auditor was leaving here, then this provision is applicable. Now the auditor is leaving in the next 45 days. In the next 45 days, any days. So first of all, let us write what are the next 45 days. The next 45 days means what? So 16 August 2020 to 30th September 2020 tak. In within these days, if the auditor is leaving within these 45 days, then there is a different obligation on the auditor. So what is the obligation on the auditor? In this case, auditor's responsibility is what, sir? In this case, auditor's responsibility is to do audit or limited review and issue report for previous quarter. That is there. For the quarter which you have already completed, that quarter audit report or limited review report you have to issue for the previous quarter. But along with that, auditor must complete audit or limited review of such quarter also in which he is leaving. In which he is leaving and must issue what? A report for the same. Are you getting the point? The same. Sir, what do you mean by that? Now listen to this. In case of red area, sir, what was red area? He was leaving within 45 days. First 45 days from the end of the quarter. in this only quarter number 1 was the responsibility of a leaving auditor. But now in this case, he's leaving where? Sir, in this case, he's leaving in the next 45 days. In the next 45 days, it means from the 46th day onwards to the 90th day of next quarter. If he is leaving in next 45 days, then in that case, quarter 1 plus quarter 2, both will be his responsibility. And this rule is applicable everywhere. This rule is applicable everywhere. Now suppose the same thing happens here. Now let's take an example. If the same thing happens here, let's take an example. This is the half of quarter 3. Are you getting the point? If the same thing happens here, he leaves in these 45 days. If he leaves in these 45 days, now what will happen, everyone? If he leaves in these 45 days, now what will happen? If he leaves in these 45 days, then the auditor's responsibility is what? Quarter 1 plus quarter 2. But if he leaves in these 45 days, then the auditor's responsibility is only quarter 1, quarter 2, or it is a responsibility of quarter 1 plus quarter 2 plus quarter 3. So if you are living in the first 45 days of the next quarter, then previous quarter is your responsibility. But if you are living in the next 45 days of the next quarter, next 45 days of that quarter, then previous quarter and the quarter in which you are living, that is your responsibility. So it means here, as per the example, here the auditor is leaving in the third quarter after 45 days. Then in that case, quarter 1, quarter 2, quarter 3, all three will be his responsibility. But if he leaves in these 45 days, then in that case, quarter 1 and quarter 2 only will be his responsibility when it comes to the audit or the limited review. This is what is being written here. But what is the third point being talked? Third point is completely different. So what is the third point? So third point may, what the act is saying, in the third point they are saying that if the auditor leaves at any point of time in the last quarter, if the auditor is resigning at any point of time in the last quarter, in the which quarter? In the last quarter. To try to remember, in the first quarter, though, if he leaves, then it is a previous year case. In the quarter 2, if he is leaving in the first 45 days, in the next 45 days, that is a different issue. In the quarter 3, if he is leaving in the first 45 days, in the next 45 days, that I already told you. But if the auditor is leaving at any point of time in the last quarter of the financial year, then in that case, what will happen? In that case, the auditor's responsibility is what? Auditor's responsibility is for quarter 1 plus quarter 2 plus quarter 3 already, plus quarter 4, as well as yearly audit or limited review report. Are you getting the point? Then in that case, you have to complete your assignment for the full year. If you are leaving in the last quarter, means from January 1st to 31st March, at any point of time you are leaving in 2021, then in that case, quarter 1, quarter 2, quarter 3, so already you might have done. Then quarter 4 also you have to do, and the full year audit report and the full year limited review report also you have to give. This is what the whose responsibility? So this is what the auditor's responsibility. Are you getting the point or not? Yes, sir, we got our point. So this is what the next 45 days point. This is what the first 45 points. So can I see that these two situations are applicable in quarter 2 and quarter 3. But if the auditor is leaving at any point of time in the quarter number 4, then in that case, full year audit and limited review is compulsory. So this is what the understanding you have to make sure. Are you getting the point or not? Now let us read what is written in the amendment and let us see whether we are able to interpret the amendment given by the LODR regulations or not. Now what is the amendment saying? So instead of writing it here, because that was not possible on the left side to be written, that's why it is written here. So along with that, these notes also will be shared with you, right? Everyone, please try to understand. If the auditor resigns within the 45 days from the end of the quarter, it means we are talking about the second quarter, but the first 45 days of the financial year, then the auditor should, before resignation, issue the limited review or audit report of such quarter. Are you getting the point? Right? If the auditor resigns after 45 days from the end of the quarter of financial year, then the auditor should, before resignation, issue the limited review audit report of such quarter as well as the next quarter. It means the quarter in which he is leaving, that quarter audit report, as well as the quarter which he has already completed. Both the quarters are responsibility. Notwithstanding anything above, now it is talking about the last quarter. If the auditor has resigned, the limited review and audit report for the first 3 quarters of the financial year, then the auditor, before resignation, issue the limited audit review of the last quarter of such financial year as well as the audit report for the such financial year. If you are leaving at any point of time in the last quarter, then the already 3 quarters report you have already might have given, plus that last quarter report also you have to give. What? Audit and limited review report, plus the full year audit report also you have to issue. This is what the responsibility, this is what, sir, this is what the responsibility of, let us write. So this is what the responsibility of statutory auditor of listed entity and its material subsidiary. Clear, everyone? So that brings an end to up to this much of amendment. Right or not? Major thing was that only कि what is the obligation on auditor. तो again repeat कर लेते हैं. If you are leaving in the second quarter, but in the second quarter you are leaving within the first 45 days, then you have to issue the audit report or limited review report of the previous quarter. But if you are leaving in the second quarter, but in the next 45 days of that quarter, then the previous quarter audit report and this quarter which you are leaving, that audit report is also your responsibility, and this is applicable for the second quarter and the third quarter same. But if you are leaving at any point of time in the fourth quarter, then the first 3 quarters, so already you might have done the audit or limited review, then that quarter in which you are leaving, that is the fourth quarter, that quarter report also you have to give, and the full financial year report also you have to give. This is what the responsibility of the statutory auditor of a which entity? Listed entity. And the total purpose, the total concept is written in the right side of this video. So make sure that you just shut down the video for a moment of time, or just when you are reading this video, make it on the slower pace and start writing along with me. Right? Now, procedures to be followed in relation to resignation of an auditor. So in case the auditor gives the resignation, what is the procedure to be followed by the listed entity and its material subsidiary? In case of any concern with the management of the listed entity, its material subsidiary, such that non-availability of the information, non-cooperation by the management, which may hamper the audit, the auditor should approach the chairman of the audit committee of the listed entity. The audit committee should receive such concern directly and immediately without specifically waiting for the quarterly audit meeting. What basically they are saying that? Basically, in this particular topic, they are saying that if the auditor is resigning due to the non-cooperation what he has received from the management, or due to the non-availability of the evidences which he has demanded from the management. So basically, they are saying that in case the auditor is resigning, sir, what can be the reason of rising? Either non-cooperation by management. Suppose the auditor was expecting some good cooperation from the management of that listed entity or material subsidiary, but that management was not ready to cooperate. Plus, or there might be a case of non-availability of information demanded from management. Are you getting the point? In case the auditor is resigning due to any of these two reasons, then in that case, what will happen? The auditor should directly approach to the chairman of audit committee. He will directly approach to the chairman of audit committee, and the chairman of the audit committee has to take an immediate action. Chairman of the audit committee has to take an immediate action. Sir, immediate action required because it's a very big concern. Why the management is not cooperating with the auditor? Why the management is not giving the information what the statutory auditor is asking? Then in that case, it is a responsibility of that auditor that make this complaint directly to the chairman of the audit committee. Chairman of the audit committee has to take the immediate action, but not later than its but not later than its quarterly audit committee meeting. So audit committee basically should not wait for its quarterly audit committee meeting and take the action immediately. That is what is being given. Now let us read what they are trying to tell. So they are saying that, now listen, in case of any concern with the management of the listed entity or material subsidiary as a non-availability of information, either they have not given you any information or they have shown you any non-cooperation by the management which may hamper the audit process, and the auditor should approach directly to the chairman of the audit committee of that listed entity. The audit committee should receive such concern directly and immediately without specifically waiting for the quarterly audit committee meetings. Immediately, it is the responsibility of the audit committee. Immediately they should take the action and make sure that the problem is resolved. If it is resolvable, if the problem is not huge, then the audit committee will try its all level best to resolve the problem immediately. In case the auditor proposes to resign, in case the auditor proposes to resign, all concerns with respect to the proposed resignation along with the relevant documentation should be brought to the notice of the audit committee. In such cases where the proposed resignation is due to non-receipt of information or explanation from the company, auditor should inform the audit committee the details of information explanation sought and not provided by the management. So what they are saying that in case, in the first point they were saying in case the auditor has not received the information from the management or non-cooperation from the management, directly he will go to whom? Audit committee, and make a complaint. Audit committee will take the immediate action. But in case the auditor thinks of resigning, in case the auditor is thinking of resigning, and the reason of resignation, and the reason of resignation is what? Non-cooperation or non-availability of information, then in that case, audit committee, audit committee has to do what? So what is written in the provision? Then in that case, audit committee of the data sort and on. Now, in such case, what the audit committee will do? Audit committee will immediately take an action. So basically, what is the difference in the point number 1 and point number 2? In the point number 1, auditor is directly going to the audit committee and saying that your management is not cooperating with me and your management is not providing me the information. Please take the needful action. Then the audit committee directly will take the action. But if the auditor thinks that resignation is the only option now, still after the audit committee has taken the so many initiatives, still management is non-cooperative in nature and still the management is not giving me the evidences, then the auditor should give the total proposal of his resignation to whom? Audit committee, and saying that ki bhaiya, I am resigning, please take care of your entity. That is what is written in the point number 2. Now what is happening in the point number 3? On receipt of such information, on receipt of such information from the auditor relating to proposal or resile as mentioned above, the audit committee board of directors, as the case may be, should deliberate on the matter and communicate their views to the management and auditor. Then the point number 3 mein what they are saying that ki on receipt of proposal of resignation from statutory auditor, then what the audit committee has to do. So basically we are doing the responsibilities of the audit committee now. Sir, auditor responsibility in the above we understood about the 45 days and all those things. Now we are talking about the audit committee responsibility. So first, audit committee should take the necessary action if the auditor complained about the management's non-cooperation and non-availability of information. In the second case, audit committee is receiving the proposal of resignation. In the third point, what the audit committee is saying, on receipt of proposal of resignation from the statutory auditor, audit committee or board of directors shall communicate the same to the management ki bhaiya, due to your non-cooperation and due to non-availability of the information what he was seeking and you have not provided, our auditor is leaving the company. This is what the auditor, this is what the responsibility of the audit committee. Now there is a very important point, very important point. He is saying that if the auditor does not resign, if the auditor does not resign, in the first case we are understanding that sir, auditor resigns, But in case the auditor does not resign, then what the auditor should do? Then it is a responsibility of the statutory auditor that he should give the appropriate disclaimer of opinion as per SA 705 revised. Clear everyone? Point number one, management is not cooperating. Management is not providing the availability, and auditor thinks that no, I will not resign. Now what the auditor will do? In that case, the statutory auditor, with the help of proper if he thinks that the possible effects of that non-availability of the sufficient and appropriate audit evidence is having both materiality and pervasiveness, in that case he should give the appropriate disclaimer opinion. Sir, when do we give the disclaimer opinion as per 705? When there is a non-availability of the evidence and the auditor thinks that the possible effects of such non-availability of the audit evidence or non-availability of that information could be both material as well as what? Pervasive. Then in that case he will give the disclaimer of opinion as per SA 705 revised. Clear everyone? Yes sir, we understood. Right? So see, in case of listed entity, its material subsidiary does not provide information required for the auditor, then to the extent the auditor should provide an appropriate disclaimer in the audit report, that disclaimer should be in accordance with the standard on auditing. So what standard of auditing? SA 705. Who makes it? Sir, ICAI makes it. But nowadays, who is taking a toll over the ICAI? NFRA. So you have to write the standards on auditing which are specified by ICAI or NFRA. Other procedures. Now listen to this. Auditor left. Auditor left. Now, do you have to reappoint the another auditor or not? Do you have to appoint the new auditor or not? So remember one thing, that when you are appointing the new auditor, when you are appointing the new auditor in the place of resigned auditor, you have to make sure that the company should first only define some rules and regulations in the terms of appointment. It means the new auditor should already have the knowledge why the previous auditor has left, and company wants the new auditor to know about this situation, and everything should be noted in his terms of appointment itself only. That is what is written. Now see what the standard is saying. Standard is saying that a listed entity or its material subsidiary is required to ensure that the listed entity or its material subsidiary is required to ensure that all the above conditions as mentioned for appointing, reappointing of an auditor procedure to be followed in relation to resignation are included in the terms of appointment of a statutory auditor at the time of appointment or reappointment of an auditor. So when you are appointing, so here they are saying that when audit committee or board of directors are appointing new auditor, they are appointing new auditor, then every information about above resign above resigned auditor must be already included in the terms of appointment of new auditor. So when you are appointing the new auditor, make sure that new auditor is already aware of why the previous auditor has resigned. So basically this is what they are telling in this particular point. Certificate of compliance. Now what do you mean by certificate of compliance? So we have to go to one. Now remember one thing, wherever the word called compliance is coming in, remember practicing company secretary should come to your mind. Now a practicing company secretary is required to certify the compliance of provisions of circular by the listed entity as mentioned above in their annual secretary compliance report. So you have to hire a practicing CS, and practicing CS in its secretarial audit report will report that SEBI LODR regulation has been complied by listed entity. Clear? So it is the responsibility that keep practicing company secretary in a secretarial audit report should give an assurance that yes, the particular circular of the SEBI has been complied by this listed entity. Next point, sir. obligation of the listed entity and its material subsidiary. So we understood the obligation of auditor, 45 days and all. We also understood the obligation of the audit committee in that, and now we are going to understand the obligation of the listed entity and its material subsidiary if the statutory auditor is resigning. That we already know. That we already know. So what is that? What is the obligation, bhai? First one. The circular prescribes the following formats and the disclosures to be filed by a listed entity and its material subsidiary to the stock exchange. Do you remember that the listed entity and the material subsidiary has to ensure that within 24 hours from the reasons received from auditor, we have to inform to the stock exchange within 24 hours. But how to inform, in which way to be informed, that we have to understand. So now the topic name is known as format of information to be obtained from the statutory auditor upon resignation. What kind of information we are looking from the auditor, what kind of information we want from the auditor, ki bhaiya why you are resigning, that we have to understand here. Now see, Annexure A of the circular specifies the format in which the listed entity material of subsidiary should obtain information from the auditor on resignation. The format includes information to be filed by the statutory auditor as such. Detailed reasons for resignation. First of all, the auditor has to mention in his statement that why he is resigning. Detailed reasons of his resignation. Details of association with the listed entity and its material subsidiary, that he is working in which capacity with that listed entity and material subsidiary. Third, whether the inability to obtain the information or inability to get a non-cooperation from management is the actual reason why he is leaving. So whether the inability to obtain the sufficient and appropriate audit data was due to the management imposed limitation or circumstances beyond the control of management. So he has to tell that whether whether the imposition made by the management was intentional, whether the limitation on his scope made by the management was intentional or it was beyond the control of the management. That information also auditor has to give. And whether the lack of information would have significant impact on the financial information statements or not. Whatever the information he was asking from the management and the management did not provide that information, is there any effect of that non-availability of the information on the financial statements or not, that also auditor has to specify. And whether the auditor has performed alternative procedures to obtain the appropriate evidence for the purpose of audit or limited review or not, whether auditor also applied any alternative procedure to obtain the evidence from the different point of view or not, and whether the lack of information was prevalent in the previous reported financial statement or result. If yes, on what basis the previous audit limited reports were issued, and any other facts relevant to the resignation. So basically what they are saying that when an statutory auditor is resigning, when the statutory auditor is resigning, sir, when the statutory auditor is resigning, then what is happening? Then in that case, listed company or material subsidiary must obtain following information from such statutory auditor. Now, what information you have to obtain from the statutory auditor before resignation? That is what is written in the circular. Sir, information number one. I told you, na, there are so many things which you are not even aware of. What if the question will come on this way? Then in that case, you will curse the people like us who are the poor faculties, and you will say that faculty has not covered any point. Now, point number one, what kind of information we need from the statutory auditor? Sir, point number one. Sir, what is the point number one? Detailed reasons of resignation. That point number two, association with the listed entity and material subsidiary. Point number three, whether non-availability of information from management was intentionally done by management, or it was beyond the control of management. It was beyond the control of management. Next, whether such non-available information impacts the financial statements or not, right? Next, whether auditor tried to obtain such information which was not provided by the management with some other alternatives or not. The point number 6, whether such non-available information impacted previous year's financial statements or not. And point number 7, any other relevant information. So remember one thing, before allowing the auditor to resign from the listed entity, it is the responsibility of the listed entity to get these 7 informations from the statutory auditor, and auditor has to provide these 7 informations to the listed entity. I hope everyone is crystal clear. Yes. Further, a declaration of the above information needs to be given by the statutory that information so provided is correct and complete, and there is no material reasons for resignation other than those provided above by the statutory auditor. And here they are saying that the auditor must also declare that above information is true and correct. Whatever the information is giving above is true and correct, and there is no other information responsible for his resignation. It means he is indirectly saying that ki bhaiya, what is written above is the only reason for my resignation. Other than that, there is no other extra information due to which I am resigning. So there is no other information responsible for his resignation. Who is giving this declaration? Auditor's declaration. I hope so far everyone understood what amendment this is all about, what this amendment is all about. I hope all of you are understanding. Now, cooperation by the listed company and its material subsidiary. Now, see what they are saying, that during the period from when the auditor proposes to resign. Now, listen to this very carefully. Do you know that auditor is going to resign within 45 days? Then he has to take care of the previous quarter only. If in the next 45 days he has to take care of the previous quarter as well as the current quarter. Now, listen to this. Once the company will come to know that, generally what happens, once the company will come to know that their auditor is resigning, don't you think that the company will be angry? Yes, they will stop supporting that auditor. But as SEBI circular is saying that even if your auditor is resigning and you already know that he is resigning and he is still doing his limited audit review, or he is still doing his the audit for that particular quarter in which he has given the proposal for his resignation, it is the responsibility of the listed company and its material subsidiary to support in every manner to that outgoing auditor. Even though they know that he's proposed to resign, he has already proposed to resign, but for the at least till the time he is not resigning, till the time he is not leaving the company, till the time he has not completed his responsibility, which we have discussed about the particular listed entity and its material subsidiary, make sure that they are cooperating with the auditor like in general only. Correct? So during the period from when the auditor proposes to resign till the auditor submits the report for such quarterly financial year as specified above, the listed entity and its material subsidiary are required to continue to provide all such documents, information as may be necessary for that purpose. It means full cooperation is sought between proposal of resignation and completion. Till the time he has not completed his task, full cooperation is required to be given by the this company. Now, disclosure of the views of the audit committee to the stock exchange, that we already know. Upon the resignation, now what is a provision? Upon the resignation by an auditor, the auditor committee should deliberate upon all the concerns raised by the auditor with respect to the resignation, but not later than the date of its next audit committee meeting. That we have already understood. If once the audit committee comes to know that yes, their particular auditor is going to resign, without fail, without waiting, they should make sure that immediate action and corrective measures are being taken, or at least they should report it to the management कि भैया our statutory auditor is resigning. The views of the audit committee should be communicated to the management. Listed entity should ensure the disclosure of the views of the audit committee to the stock exchange as soon as but not later than 24 hours after the date of such audit committee meeting. So views of the audit. See, this is not the intimation of reasons of resignation. That is intimation of reason of resignation by the listed entity and material subsidiary to the stock exchange within 24 hours from the moment they receive the reasons of resignation. That is different. This is different. This is the views of audit committee. Are you getting the point or not? So basically what they are doing, basically what they are saying, now see, once the audit committee comes to know that their stat auditor is resigning, then immediately by the next audit committee meeting, they should put their views on that and communicate it to management and ensure that their views on such incident must also be filed with whom? Stock exchange within 24 hours of audit committee meeting, within 24 hours from the conclusion of that audit committee meeting. That's what they are saying, that the listed entity must shall ensure to disclose the views of the audit committee to the stock exchange as soon as possible, but not later than 24 hours after the date on of such audit committee meeting. Within 24 hours after the date it is written, after the date of such audit committee meeting, it is written that suppose the audit committee meeting gets over on 16 August, then in that case from 17 August in the whole 24 hours they have to make sure that they should inform this information to the stock exchange. So listed entity has to inform two things to the stock exchange basically. What are the two things? Listed entity has to inform the reasons of resignation within 24 hours the moment they receive, and they also have to inform the views of audit committee to the within 24 hours from the day on which the audit committee meeting got ended, and this all is required to be responsibility of which entity? It's the listed entity and its material subsidiary. Clear everyone? And these both are required to be filed with whom? Stock exchange. Correct everyone? So this brings an end to this particular topic. Now, responsibility of the auditor under SEBI LODR regulations with ICA implementation guide. What they are saying that is SEBI has already told some responsibilities of an auditor, and ICA also has issued one guidance note on such kind of issues. So what they are saying that yes, the 2013 Act requires only the auditors to communicate reasons of resignation to both company and the registrar. Recently, SEBI has amended the listing obligation and made it mandatory for the listed entity to disclose to the stock exchange the reason of resignation within 24 hours of receipt of such a resignation, and ICAI has also issued one guidance note on the same. Clear everyone? Now, circumstances leading to withdrawal or resignation. Circumstances leading to the withdrawal or resignation. What they are saying that if the auditor thinks that disclaimer is not the option, the only option available with him is resignation only, then he should resign. But sometimes what happens, some laws and regulations do not allow the auditor to leave the organization. They do not allow the auditor to leave the organization. In that case, what the auditor should do? In that case, at least auditor is having another power. He can use that power called modified opinion. He should disclaim his opinion in the auditor's report. That is what is written here. So what they are saying that until and unless there are circumstances they are covered by the standards on auditing, SQC and the code of ethics issued by the ICA, where resignation is the only available alternative, the auditor should complete the engagement. They are saying that ki until and unless the last moment has come ki auditor has to resign, if he thinks that ki yes, there is a little bit of hope, ki yes, instead of resigning I can complete my engagement, then he should complete his engagement first. But if he thinks that it is completely gone out of control, now he cannot manage to complete his audit or cannot manage to complete his assignment, then he should resign. So they are saying that unless there are circumstances of code of ethics or SQC or the required standard of auditing suggests that resignation is the only alternative, till that time, until that happens, till that time auditor should try to complete his engagement. If the auditor has substantially completed the audit, then the auditor may decide to complete the audit to the extent possible and disclaim an opinion and explain the scope limitation with the basis of disclaimer opinion section prior to the withdrawing. He's saying that if you have already substantially completed the audit, but at least make sure that you should include one disclaimer opinion before resigning or before withdrawing in your auditor's report. They are not forcing. See, SEBI circular is not telling the auditor to compromise. They are saying that, okay, leave, but at least if you have done the substantially the part of an audit, at least complete the audit, give the disclaimer report so that the all users of financial statement can understand ki why the hell you have resigned from this listed entity. Include the disclaimer opinion paragraph before withdrawing. In certain circumstances, withdrawal from the audit may not be possible if the audit is required by the law or regulation to continue the audit. That's what I was telling you. Sometimes the auditor is not allowed to withdraw. He has to continue. In such cases, therefore, advise that auditor should discharge his or her professional obligation. Then चुपचाप अपना काम करते जाओ. Disclaimer opinion paragraph already is there with you. Disclaim your opinion in the form of modified report. In case an auditor has signed all the quarters financially except the last quarter, then the auditor has to finalize the audit report for the said financial year before resignation. That we already know. If the auditor is giving the proposal of resignation in the last quarter, then the first 3 quarters he has already completed. It is his responsibility to complete the fourth quarter as well as the annual report. So all those things which were discussed earlier are being again discussed here. So that's why I'm not going to write anything. In other cases, the auditor should resign after issuing the limited review for the previous quarter with respect to the resignation. That we already know, before 45, after 45, and this is what they are basically explaining again. Right or not? So let us wind it up as soon as possible. So this is nothing but the again repeated again in the what do you say material. And next one, comments. I already told you why particularly this LODR regulation came, sir. Why? Because resignation of the statutory auditor is a huge concern. It is a huge concern of an, you can say that investor, from the investor's point of view, lender's point of view. That is what is written. Now listed entities may take note to the circular as additional onus, means it is an additional burden on them, is casted on them for the disclosure of information in case of resignation of statutory auditor. In the past, whenever there has been any auditor resignation, its impact has been quite adverse for the investors, and hence in the interest of protecting the interest of the investors, the rule of resignation by the auditors have been strengthened. However, the circular does not prohibit resignation of auditor but aims at an orderly resignation. They are saying that ki bhaiya, give the resignation, but give orderly resignation by following all these things. In between, if you leave the listed company, neither the company will get benefit, nor you will get benefit, nor the SEBI will get benefit, nor the investors will get benefited. Complete your task to the maximum possible, give the resignation, go with respect, go out of the company with respect. And if you have already done the 3 quarters proposing to resign last quarter, then don't do that. Do the full year and then leave. If you are leaving in the first 45 days of the next quarter, then at least complete the previous quarter report. And if you are leaving in the next 45 days, then the previous quarter as well as what? This quarter. To make sure that they are not prohibiting you from resigning. Basically, the SEBI is trying to strengthen this particular thing because it really affects the investors. It really affects the interest of investors. So to protect and to strengthen their interest, this provision has been given कि give resignation, but give a which resignation? Orderly resignation. I hope all of you understood. Yes sir, we understood. So that's it, is all about particularly talking about the resignation of internal auditor, sorry, resignation of statutory auditor in case of LODR regulation. So that brings an end to our chapter also, and that brings an end to the very important amendment which the ICA has recently introduced. So with that, I would like to take your leave, and I hope that all of you understood. I hope that all of you understood this amendment and each and every point now you have understood. Make sure that and promise me that if this question will come in the examination for 4 or 5 marks, you are going to comment on my YouTube channel immediately if you think that this particular question has come, and if you are able to retain the various things which I have told you in this particular video. So thank you so much for listening to me. Thank you so much for coming live or taking out your precious time to watch this video, and I will again suggest that watch the full video. Don't leave the video in between because there are so many minor points in between. So thank you so much. Thank you for lending your patient ears. I'll again borrow your ears in the next video. Thank you so much. Bye everyone. Take care. Stay safe. Stay at home. Bye.